and I think some of the people in the audience might not appreciate this, is that evidence taken in international arbitration is not subject to the civil procedure rules of the law of the seat of arbitration, or for the matter, any other law. Instead, it is driven by arbitrary practice and some of the soft law instruments, or maybe not so soft law, including the IBA rules on the taking of evidence in international arbitration. And to explain that arbitral practice, we have a very distinguished panel today that I'm going to introduce in a second. So let me start with Rusa in the order that the speakers are going to speak. So Rusa Tchkuaseli is a partner at BLC Law Office, a top-tier law firm in Georgia. She has been recognized as a next-generation partner in multiple practice areas, including banking and finance, commercial, corporate, M&A, and relevantly for our purposes, dispute resolution. And Rusa is a former president of the Georgian Association of Arbitrators. Then we have Levon Golendukhin, who's a counsel in the New York office of Eversheds, Sutherland, where he advises clients in all aspects of international dispute resolution. Levon also served as a founding member of the board of trustees of our own AMCA. And one thing that you wouldn't be able to find on his website is that he's very good at Armenian folk dances. Then we have Natalia Petrik. Natalia is a counsel at Westerberg Partners in Sweden, where she focuses on international dispute resolution with a particular emphasis on commercial and investment arbitration. And prior to coming back to private practice, she was the Deputy Secretary General at the SEC Arbitration Institute. She also served as a board member of the Finland Arbitration Institute, a member of the advisory board of the Stockholm International Hearing Center, and secretary of the executive committee of the Swedish Arbitration Association. And then we have Raëd Fathallah, who is a partner in Bredin Prat's international arbitration team in Paris. He acts as counsel in large-scale and complex investment and commercial arbitrations, in which he represents corporations, sovereign states, and state entities. Raëd is also an accomplished arbitrator. He's also vice president and a court member of the LCA, a member of the ACC Commission, and is also on the ICSID panel of arbitrators and conciliators. And last, but certainly not least, we have Florian Haugeneder, who's a partner at KNOETZL, a law firm specialized in international dispute resolution. Before co-founding KNOETZL in 2016, Florian was the head of the arbitration practice of an international law firm. Florian was a board member of the Austrian Arbitration Association from 2016 to 2020, and is president from 2020 till 2022. He also lectures at the University of Vienna. Now, with the introductions out of the way, I think we're ready to start with the substantive discussions. So we're going to do some presentations, and then we'll have some questions as we go through. And Rusa, the floor is yours. Rusa is going to speak about the witness evidence in international arbitration.
Thank you, Hayk. Good afternoon, everyone. I hope you had a very good lunch and a strong coffee to keep you going after the lunch. Well, big thank you to AMCA for having me here in this panel. This is my first time in Yerevan. I've been planning to come here for a long time now, and it's a pleasure to be here and pleasure to share this discussion with the esteemed colleagues of mine. Indeed, I will be speaking about witness preparation and what happens when the witnesses do not show up at the evidentiary hearing. That's a disaster, but that sometimes happens, and we can discuss the impact that may have on the outcome, as well as what can the counsel do to kind of prevent that from happening. So focus of today's panel is navigating legal traditions in evidence taking, and I think witness testimony and witness evidence is one of the areas where this cultural difference between different legal traditions show the most. I'm from the civil law country. Georgia is a civil law country, and in most civil law jurisdictions, we do not put much emphasis on the witness testimony. It's mostly about the documentary evidence that you produce, but there's in the common law countries, I understand it's quite the opposite. The witness evidence has great weight, and I think the international arbitration is a sort of a combination of both. And preparation of the witness, when we talk about preparation of the witness, that starts from the very beginning, once you decide who your witness should be, and then, continues all the way to, from drafting the witness statement and to preparing witness for the cross-examination. Now, when it comes to the drafting of the witness statement, that's also something that the counsels do in a different manner. We've seen and we've worked with counsel, and we've seen the counsel drafting the witness statement for the witness based on the documentary evidence, but we've also seen, witness taking lead on drafting its own witness statement, his own witness statement, or at least taking notes, which then the counsel can, enhance and put in a proper form. And me personally, I'm a fan of the second option, where the witness holds the pen on the first draft, or at least the witness statement is drafted following the interview with the witness, where the statement very closely follows to the phrases that the witness uses. And I recall we had a case where we had a very diligent witness. That also depends on the witness. Some witnesses are not that diligent. They simply ask you draft it and I'll sign it, or I'll review and sign it. But we had a very diligent witness who drafted his own witness statement, and he remembered this very a peculiar phrase from the negotiations, where the counterparty told them that, we know this contract will be signed today, but once the financiers are here, we'll know that they will reopen it and they will drill the holes in this contract, like in the Swiss cheese. And he remembered this very phrase, and that phrase in his witness statement basically brought his witness statement to life, gave the amazing credibility to his witness statement, and then he testified in front of the tribunal, yet again saying that that's how that was said, that phrase was said, and that basically was a turnaround for the case, because that meant that the terms of the contract were not set in stone. The understanding was that the financiers, the banks, for the bankability purposes, would reopen the contract. So that was very, effective phrase that kind of gave additional credibility to his evidence, which phrase could have been lost if, we were to draft his witness statement, because I was not in the room. I didn't know that was said, right? So that's also something that is part of the preparation of the witness statement and witnesses in general. And once we have the witness statement, then the next milestone is the, witness coaching or witness preparation, not coaching. And there is a fine line between what's the preparation that is allowed and what is considered to be coaching. And well, we've all worked with the clients, and we all know that, even very sophisticated senior executives, they look for the guidance of the counsel about, what's the witness box looks like, what's the procedure, what should I respond, how should I respond? All of those questions come, and we're there to assist, but to the extent that is allowed. And what is allowed when preparing a witness, that's not really a straightforward, there's no straightforward answer to that question, because although there are, IBA guidelines that say that it's not improper for the counsel, for the party to discuss with the witness statement or witness testimony or potential witness testimony, there's no much guidance on the procedure or how detailed that discussion could be, or what issues and topics should be discussed, or etc. So there's no clear guidance on that, and what we are left with basically is to, understand, first of all, whether there is any, regulation at the seat of arbitration that sets the boundaries, what are the ethical standards that apply to the counsel that is involved in the case, what's the taste of the tribunal, because we've once had a witness that was completely unprepared. He even didn't know what to wear and came to the evidentiary hearing with a T-shirt, and his answers were genuine and frank, and then when we received the award was the tribunal was very sympathetic to that witness who was completely unprepared in terms of, what the procedure would be, what the questions could be, or how to best respond to the questions. But for, it's also a matter of taste. For other members of the tribunal, that could be a, kind of disrespectful approach maybe from the witness side. So, that all in combination really depends. And we know that in UK, and my colleagues here are better placed to probably comment on that, but I understand that there are quite strict rules on, how to prepare witness, that shouldn't be coaching, to the extent that witness evidence should be a genuine recollection of what witness actually remembers and how witness remembers it. And the counsel is not allowed to kind of interfere in the substance of the witness statement, but other than that, explaining procedure, preparing witness to, for this very stressful experience, because it's stressful for everyone, including lawyers sometimes who have to testify, right? That's completely fine, and that's okay. So, I mean, in absence of detailed guidance on that, I tried to kind of put together the bullet points of what is generally considered to be allowed, and how to best prepare the witness. Of course, my recommendation would be to visit the guiding, maybe the rules of the arbitration, as well as the law of the seat of arbitration, and of course the ethical rules of the counsel. But in general, basically directing witness to look through the contemporaneous evidence to kind of refresh the memory, that is fine, that is considered to be fine. Also, ahead of the evidentiary hearing, asking the witness to read the witness statement and read the documents that the witness statement refers to, that is also fine. Besides, the counsel can direct the witness on the critical points of the witness statement where the witness is expected to be asked the question. So we're not proposing answer, we're not putting answer in the witness's mouth, but rather we're saying that these are the controversial topics, and we expect that you will be cross-examined on those points. So make sure that you read the documents, you remember everything, and etc. Also, explaining what the cross-examination will look like. That's also very helpful, because we've seen and we all know that the barristers could be quite aggressive when, cross-examining, sometimes even humiliating. I put to you that you, Mr. Grinch, you're a fraudster.
As a matter of English law, you have to put it to the witness, otherwise.
I know, but not in international commercial arbitration, right? So I'm not saying that they are not allowed to do it. I'm just saying that the witness has to be prepared so that they do not lose their temper. They need to understand that it's not personal. They have to remain calm, and respond politely to the questions put. Also, there's a technique when witness wants to recollect and what to say, or remember the fact, or how to put it in the best way. They can ask, can you rephrase the question? Of course, when misused or used it quite often, that looks very bad in the eyes of the tribunal, but that's also something that witness can potentially do. Also, sometimes what we do when we have a Georgian-speaking witness, whether or not that witness knows English well. Of course, English is not the native language for any Georgian in general, so we always prefer to have a translator on the standby, so that if there is a difficulty in following the question, or witness simply wants some time to recollect the thoughts, witness can, ask that, can I have a translator to translate that question to me? I don't understand what's been asked. So those are the techniques. And of course, training the witness to say, I don't remember, when they genuinely do not remember. That's also that is something that needs to be said to the witness, because it's always better if you do not remember. It's better to say I do not remember, rather than invent something and come up with the wrong answers. And once we have well-prepared witness, the actual evidentiary hearing can go right. But it can go wrong when the witness refuses to show up. And that's a disaster. It's a disaster because, of course, when the witness doesn't have a good reason for not showing up, right? That anything can happen, the traffic ban, illness, emergency, but when there is no valid excuse for the witness to show up, then it's really, that can ruin the case, basically, because the default provision under the IBA guidelines on taking evidence is that the tribunal, if they don't have a valid reason from the witness for no-show, they can simply disregard the witness statement. Or the best outcome could be to consider the witness statement, but give it a low evidentiary value, so to speak. And they can, infer, they can draw adverse inferences, and generally the party and counsel loses the credibility. There's no there's no right or wrong way, or the way basically to prevent that from happening. Anything happens, but what I find to be very useful is to warn the witness ahead of the producing a witness statement that witness will be cross-examined on the witness statement, to explain what the cross-examination looks like. And if you've seen the witness statements, it includes the paragraph saying that, oh, I understand that I will be cross-examined. I may be cross-examined on this witness statement, but maybe this is not enough. Maybe we should warn the witness in writing, send a separate email saying that you understand that by giving this witness statement, you will be cross-examined. You have to make sure that you allocate sufficient time and resources for you to attend the hearing if you're cross-examined. And if they refuse in the end, at least you have something to show to the tribunal that you've done your best, and you genuinely wanted this witness to attend. You wanted this witness, the evidence of the witness, to be tested through cross-examination.
Yeah, excellent. Thank you very much, Rusa. I think, what qualifies as a valid reason is quite difficult sometimes in practice. Sometimes you might have obviously valid reasons and things which are not so obvious. With that said, now I think we can turn to Levon. And the question of what kind of documents can you request when the documents are within the possession, custody, control of a party, so they would fall within the document production ambit. Thank you.
So it's the less exciting half of discovery when you're not dealing with witnesses, but with the actual paper and documents. So, and the scope of document discovery under the IBA rules of evidence is in Article 3. And the key lodestone for that scope is the documents in the possession, custody, or control of a party. Now, what does that mean? So, possession, custody, and control, those are three different but related concepts that refer to the relationship between the document itself and a party. And when you remember that arbitration is a creature of consent, and the only parties are the ones that actually consented to arbitration, then you open the door to disputes about whether a given document that the other side wants and makes a request for is in the possession, custody, or control of a party. And most often, that dispute relates on the question of control, because if the party holds it, then there's very little debate whether you want to call it possession or custody. The question is, what if the document itself is not held by the party that is in the arbitration, but by some sort of related party? And so you might think, okay, let's look to the origin of this phrase, possession, custody, and control. As best we can tell, it comes from US civil practice. But in fact, within the US, there is variance between the states on what possession, custody, and control, and particularly control, means. Moreover, as the phrase was imported into the IBA rules, there's no guidance that says it should follow the meaning practiced in one or more US jurisdictions. And so when you review the authorities, the publicly available cases and the leading commentators, it's not a applicable law-driven analysis, so you're not using the definition of possession, custody, or control under any one US state or any other governing law, maybe the law of the subject matter, but rather it's a very fact-intensive assessment. And so maybe we do that by illustration to the key kinds of relationships that arise between the party being asked to produce and the party holding the document. So most commonly we see that in either a group of companies context, where one company signed the contract and is party to the arbitration, and another company within the same group is custodian of the documents. It could be a parent, it could be a subsidiary, it could be a sister entity, it could be somebody in the same, an entity in the same conglomerate, but in an entirely different vertical. And so you can't have the one answer for all situations. It depends on whether, in fact, the party that is in the arbitration has the ability to procure that evidence. And we'll come back to ability to procure in a bit. Another context that...
Levon, can I just ask you on that group of companies doctrine? So let's assume the doctrine is held by a sister company. And then those documents are not found by the tribunal to be within control of the claimant or respondent.
Yeah.
But there's some good indication that if the respondent asked politely, gently, forcefully for those documents, they probably would have been produced. Now, some of the judicial systems, so for instance, the English courts, see that in that case, even if you might not be able to obtain the documents or at the document production stage, there might be an adverse inference drawn against you because you didn't go and ask for those documents in the, which are held by the sister company. What do you think about that? Is that something, I mean, we know that tribunals are quite reluctant to draw adverse inferences, but do you think is there something, an argument that can work in arbitration international if you don't get that at the control level?
Yeah. So just one step back, I guess an adverse inference for anyone who may not be familiar is when the tribunal makes a factual determination on an issue in dispute that and that determination is against the party that allegedly failed to produce the document, and the inference is that the failure to produce was driven by the document being adverse to the position of that non-producing, of the defaulting party. Now, key to the adverse inference, it's essentially a procedural sanction, right? It's a tribunal sanctioning a default. Key to that is the actual default. So in the absence of an order to produce, a tribunal will not necessarily feel empowered to be making an adverse inference. Now, that doesn't fully answer your question because I think there's two related considerations. One is that possession, custody, and control of the party is not necessarily the ceiling of that party's discovery obligations. So we've seen in a handful of recent tribunals, actually, the tribunal not being too forceful in making conclusions about possession, custody, and control vis-a-vis third-party documents, but still saying the party has a good faith, whether it's founded in the obligation of good faith to arbitrate in good faith, or general best efforts in participating in the arbitration, to at least do a best efforts, to exercise best efforts to obtain that document from the third party, and on that basis, to order the requested party to do so. So when the requested party is ordered to do so, then at minimum it has an obligation to exercise best efforts. And maybe from the failure to exercise best efforts, then the tribunal could once again be in a situation of, I have a defaulting party, do I have a sanction? But at the end of the day, if it's an issue and dispute before the tribunal, even if there's no procedural sanction available, by the end of the proceeding, the tribunal has to resolve the issue. And applying burden shifting, if the other party can make a case that circumstantial evidence points to the issue being one way, and it becomes very circumspect that the other party does not produce any contrary evidence, exculpatory evidence, for example, then you can get to a point where, okay, the pleading party has shifted its burden to the other side, and the other side's failure to produce and put into record the exculpatory evidence rises to sort of losing on that fact issue. So the end result might be the same, but it's it's treated as a merits issue rather than a procedural sanction. I'm conscious of time, so.
I think it's now Natalia's turn to speak about the later.
Yes, following up a little bit on the previous topics, evidence submitted out of time, I would like to start with a question. How many of you see evidence be invoked beyond time limits, after cut-off, by surprise, and out of scope? I guess that, at least half of the audience would see this in many, many proceedings. So the topic is really relevant for commercial arbitration, and the question is how the tribunals should handle these situations. And the fact that parties very often, and users of arbitration very often witness this in arbitrations, is that this is reflected in arbitral surveys as well. In Queen Mary survey from 2015, for instance, the users were repeatedly concerned about the situations where fresh evidence was admitted late in the proceedings, and similarly in a very recent Swedish Arbitration Association's report on arbitrations in Sweden, the working group stated exactly the same. Arbitral tribunal, even upon a party's request, are reluctant to reject evidence, often similarly due to a perceived risk of annulment. And this is interesting, especially in the Swedish context, because the Swedish law on arbitration actually does allow tribunals to reject evidence if such refusal is justified having regard to the time at which evidence is invoked. So there is clear language in the law. And at the same time, it looks like, and it's quite obvious, that tribunals perceive production of documents and evidence as a part of the party's right to be heard. And this is a part of due process, and therefore they're very reluctant to dismiss evidence even when it is submitted belatedly in the proceedings. And in this context, it's very interesting to look into open sources and, for instance, exit case law annulments, how the evidence issue is dealt there and what actually happens. And I researched a little bit this, and it reveals, the practice actually reveals that it's not the outright rejection of belated evidence that leads to annulments. On the contrary, it's the contrary situation when tribunals admit belated evidence and mishandle it afterwards without giving the other party an adequate opportunity to react and rebut the new, let's say, written documentation that was produced at a belated time point. And that is very interesting. A very known case which deals with these issues is Fraport against Philippines. In that case, the procedural issue that was pleaded in the annulment stage was that the tribunal, after having conducted the hearing and at a very late stage of the proceedings, received a message from the respondent party informing the tribunal of certain material facts that occurred in criminal investigation into the claimant party, asked claimant to clarify. Claimant produced a couple of pages of new documents and also rebutted the respondent's statements and questioned the correctness of those statements. And then the tribunal goes back to respondent and says, okay, now you, just to complete the case file, you should produce the whole record of that case, criminal proceedings. And then respondent produces kind of 1,900 pages of documents. And all this was done as a part of completing the case file. And the biggest problem with that was that on one side, the tribunal factually was already deliberating the award. On the other side, and the tribunal was very transparent with the parties saying that we are not expecting any submissions at this stage of the proceedings. And on the other side, the award was rendered against the claimant, quoting the documents produced at that post-hearing stage. So the award was annulled, and there is a very interesting and instructive decision by the annulment committee on the basis of violation of basic procedural rights of the claimant party to be heard, to be given an opportunity to rebut what was. And that was a very instructive case how evidence could be mishandled. Because clearly, when you open the Pandora box and when you allow new documents out of the already agreed procedure, and at a very late stage, then you should be prepared to give an adequate opportunity to the other party to rebut this, and not just asking the party, so to say, to complete the case file. And on the other side, there are also examples how tribunals handle these issues properly. There is another very good example in a case called Burime against Albania. In that case law, what happened is that claimant, without submitting written witness statements, lately in the proceedings before the hearing, invoked a couple of witnesses to be heard during the hearing. And then the tribunal just went back to the parties and stated, but we have our first procedural order, and here we have a very important instrument how to deal with any potential complications in the proceedings. So the tribunal already in the first procedural order included a whole section dealing with evidence. And what they did is that they clearly and explicitly told the parties that any piece of written evidence, or even not written evidence, that you intend to introduce should be introduced in connection with any of your submissions and introduced in writing. And if you don't do this, then you should present any exceptional circumstances why you did not do this, and we will assess the admissibility based on these exceptional circumstances. So they rejected those witnesses and did not allow to be heard. That case was not tried by the annulment committee, but it was a very clear-cut case how to manage at an early stage of the proceedings any potential complications, just setting the rules with the parties on what is allowed, what is not allowed to do. And of course, there might be very valid reasons why late evidence should be submitted. It might be very relevant to the proceedings. It might be game-changing. It might have to deal with whatever enforceability, future enforceability of the award. And then, of course, tribunals should be prepared to establish a new protocol for handling this newly submitted documentation. So that is very important practical takeaways on how to deal with this. And of course, just I reacted to very interesting presentation by Rusa saying about witnesses not appearing at the hearing. There is also case law from the SCC in one of the Energy Charter Treaty-based cases, investor-state arbitrations at the SCC against a CIS republic, which did not participate. A technical witness at a very late stage of the proceedings informed everyone that he was not going to appear because he feared for his safety. He was not going to attest against the state. And while that was understandable, the tribunal was very transparent how they would handle this. And this is another question. If things happen during the proceedings, the tribunals must be very, very transparent on which point they are going to refer or use this piece of evidence that is either is produced or not produced. And in that case, what they said that we are going to attach very little value to this written testimony by the witness because he is not appearing and we cannot put questions and the other party is not participating. There is no objection, so that's why they did not dismiss it altogether, but they were transparent with the claimant party how they would see this piece of documentary evidence. So these are the practical examples how this can be handled. Of course, there are a lot of many other examples as there are a lot of different situations where the tribunal needs to be very transparent.
Excellent. Thank you very much, Natalia. Raëd, the floor is yours.
Thank you. And it's a pleasure to be here. And I must say, being from Lebanon, I cannot be closer to home. I'm really happy to be in Yerevan. So I will basically just touch upon the discussion over the limit of the power of arbitral tribunals and how we can provoke maybe the tribunal to go beyond its usual sort of routine management of the evidence, whereby I would maybe touch upon 2 or 3 examples where the power of the tribunals can be tested and pushed a bit further. Some of the issues have been discussed this morning, so I will go rather briefly. So I will start with the courageous tribunal, or try to put some courage into the tribunal, and move on to sort of more the proactive tribunal to discuss as to how we can trigger some movement in the process. So the first example out of the 3 examples I would give is provisional measures. This has been discussed at length in the previous session, so I will be rather quick. But I would say it's an overlooked tool. And why do I say this? We discussed burden of proof, we discussed shifting of the burden of proof, we discussed also drawing adverse inferences. But one thing is very important: if you don't have your evidence, if you don't have your documentary support, for example, to establish your quantum claim, you can be done. As much as the tribunal may have sympathy to the fact that you no longer have access to your documents, if you don't do something about it early in the process, that can be quite outcome determinative. So why do I say an overlooked tool? Today, arbitration rules, model law, they provide for specific provisions with respect to the preservation of evidence. So starting with the, or empowering tribunals to enact measures with respect to undisclosed evidence. So for instance, Article 17.2 of the model law refers specifically to the preservation of relevant evidence and provides for interim relief to achieve that. Article 26.2 of the UNCITRAL rules also refers to that. And what's interesting in Article 26.2 of the UNCITRAL rules, it goes further, whereby the requirements of irreparable harm and the reasonable probability to succeed on the merits is somehow toned down, and those are provided under Section 3, whereby Section 4 says that these requirements only apply, or apply only to the extent the tribunal considers appropriate. So somehow it's reducing in a way the threshold for such interim relief in the context of evidence. The same also was discussed this morning with respect to the ex parte, the possibility to obtain ex parte interim relief in the context of disclosure. So I would not go through the requirements and how it can apply. I move on to the exit context. Here also the exit rules are quite clear, and it empowers the tribunal to issue provisional measures, also with respect to evidence. And also exit rules go even further, whereby the tribunal can issue such measures on its own initiative under Article 39.3. And there are two examples where this occurred in Pecasado versus Chile case and the Bywater Gulf Tanzania case. Now, I will not go through the test of what it requires to meet the test to obtain such interim relief. Sergey has amply discussed it this morning. But I'll give you one example. There are three cases I'm aware of. The first one I was personally involved in, whereby our client claimant files a request for arbitration against a state within weeks before the constitution of the tribunal, within actually a few weeks. The state decides to send the police to raid all its offices, confiscate all documents, and take down all servers, which meant that all of our evidence disappeared before even the case started. So we filed for provisional measures, but we actually filed for urgent, some sort of a restraining order before the tribunal was constituted. And as you know, under the rules, basically the tribunal would decide ultimately, but a procedural calendar can be put in place for the parties to have a speedy exchange on the issue pending the constitution of the tribunal. To make a story short, the tribunal issued an order requiring respondent to provide us a copy of the documents, because respondent put forward the argument, criminal investigation, it's mine. And respondent's defense team said, well, I cannot give any orders to the prosecutor or the attorney general. We cannot mix the two. So the tribunal was careful not to encroach on the sovereignty of the state and its power to investigate to conduct criminal investigations, but ordered the respondent to give us a copy of the documents. What happened? Respondent resisted nonetheless. We obtained a cost order ordering respondent to pay all the costs relating to that phase before we even filed the first submission on the merits. Now, does this solve the problem of not having access to your documents? No, but it helps you going forward to argue shifting of burden, I don't have the documents, and why do I don't have those documents? So it's important, I think, to be very alert and proactive when it comes to preservation of evidence. The second, and I'll be very brief on it, is the use of national courts in support of arbitration. There, I think we're all aware of how this works, but I'll be very brief. The IBA rules on the taking of evidence allow and provide for the possibility of using national courts to obtain evidence even from third parties, and where, for example, the ancestral model law also provides in Article 27 that this is also possible. Now, the limitations, to be very brief, such remedy or such possibility can only happen in a jurisdiction if the tribunal is seated in a jurisdiction that allows that, and therefore a jurisdiction of the model law. And it can only be allowed if requested and approved by the arbitral tribunal. So here I'm talking about obtaining interim relief, sorry, I should have been clear, during the arbitration proceedings. And thirdly, there's a nuance here that the assistance can only exist to obtain evidence or witnesses, for example, that should be heard or required for the hearing. So it cannot be used as a disclosure mechanism pre-hearing. So that's also, although there are some courts, especially in the US, that have applied this in a nuanced way. Now, quickly, we have like some provisions on the French law and English law that resemble this. For example, Article 1469 of the French Civil Code of Procedure, the English Arbitration Act, even as modernized recently, Section 44, now expressly provides for that and also allows a party to apply to seek obtaining evidence in the possession of a third party. Section 7 of the US Federal Act, all of those follow the same pattern as long as you obtain the approval of the tribunal sitting in place. So that's the second point. The third point, which I would say is more problematic, it's not a question of a limit as much as a question of power, is the ability of a tribunal to order evidence to be produced sua sponte, meaning of its own initiative. Now, as you all know, this has triggered many debates over decades, as to what approach tribunals should take. Should they be proactive, not proactive? Are there any due process violations or concerns if a tribunal puts questions or questions a certain evidence or asks for more evidence from parties if the parties have not put forward these issues before them? I will not get into it, but I would say one thing that now has changed completely the game is when it comes to corruption allegations. So now it's not a question of actually having the authority to do it. It has gone as far as actually considering now that the tribunals have the duty to do it, to investigate. So, and I again just refer to French case law, and in brief, there's the Sorelec and Bellecon cases, where now, in France, we moved from a minimalistic approach, whereby you look at the evidence before you as arbitrator, and then it goes to the Court of Appeal, which is the court that would look into the set-aside proceedings, and the Court of Appeal would not second-guess or question the decision of the tribunal. But in this recent case law, actually, at the appeal stage, before the Court of Appeal, the French courts are allowing new evidence that has not been produced during the course of arbitration. But not only this, even if the party cannot show that it could have reasonably divulged or produced this evidence during the proceedings, the French courts would accept this new evidence. So therefore, parties, I would say in a somehow disloyal way, can post facto or keep under their sleeve a corruption allegation and raise it at the challenge stage. Now, other courts have taken a more reasonable approach, I would say, or a more nuanced approach. For example, in the UCOS case before the Amsterdam court, or in the PIND case, very much discussed against Nigeria. So the test as to whether the party could have reasonably put forward this evidence before is an important factor. French courts have recalibrated the debate. But why do I say this? Today, I think the moment a party, whether in good faith or bad faith, mentions the word corruption, you have to expect that arbitrators will take a proactive approach in seeking evidence. Quick example, I'll be very brief. One case where unpaid invoices, all the invoices were approved. A party, a state party, chooses not to pay. Arbitration proceeds, commercial arbitration, everything finishes. At the last day of the hearing, a party raises the argument of corruption. So the tribunal panics. What does the tribunal do? They invite the other side to produce whatever. At our request, actually, we challenged the other side and said, well, just show us the evidence. Please produce the criminal record. Of course, they don't want to produce it. Anyway, all this to say that, to go back to your example, the tribunal asked for the witnesses who testified, some of them were beaten up and jailed, to testify, to give evidence, to appear before them and be questioned. But also they asked for a person from our client's side to show up, and we said that this person cannot testify because we need to protect that person against the self-incrimination. That's a basic fundamental principle. Now, interestingly, the tribunal did draw adverse inferences from the fact that the witness refused to show up. You see, now, the tribunal found in our favor in the award, but you can tell that what tribunals do now, they go as far as they can to create a new phase and to go as far as they can in terms of hearing evidence in order to ensure that the award is not challengeable or not challenged, even if it's somehow in an artificial way, knowing that these corruption allegations were bogus and completely unsubstantiated. In 1 minute, maybe, if I have, I will move on now to the proactive, I would say, tribunal. I think a big risk that we have in international arbitration is what someone has mentioned as an example recently, tribunals being on autopilot mode, where they follow the normal process, first submissions, rounds of submissions, doc prod, second round of submissions, hearing, joint reports. I think also when it comes to evidence, sitting as arbitrator, but also appearing as counsel, we often realize that close to the hearing, the tribunal doesn't have what it needs to rule on the case. The way, be it the evidence is presented in terms of method or in terms of the evidence that is needed. And often all these joint reports become useless or the hearing becomes actually not very efficient. So I would mention 3 ideas here. The first one is basically to have an early case management conference whereby when it comes to experts, be it legal experts or technical experts, whereby the tribunal will try to agree with the parties and the experts on the methodology and the data required for them to prepare their reports. And why is that important? Because we often see that after numerous reports, the entire debate at the hearing is about methodology and data. and not about what is the expertise. And that's very important. That's number one. And that's why sometimes we get the impression that the expert reports or presentations are not actually made for the tribunal, but the expert is making presentation for the other expert. The other one is document production. Levon touched upon it, but one technique that we have found with my partner Marina in a case that is quite useful is to limit the number of document production requests. Some tribunals do that. And if a party feels the need, it can apply to vary that limitation. That's number one. But number two, to have also a case management conference whereby the tribunal discusses live with the parties those applications. And often you see that the parties are somehow encouraged yet enticed to limit the scope of their requests or reduce certain requests when they are discussing them live in the presence of a tribunal. Because again, I think that's quite problematic. And thirdly, again, I go back to experts. I think another sort of case management conference number two, a midstream conference, can be quite helpful, whereby after the first round of submissions is done, the tribunal has a full knowledge of the case, and a first round of expert reports. The tribunal can invite the experts to agree on the list of issues, but also to agree on the approach for the second round before it's too late. And that's very, very important. Otherwise, again, you have this notion of like ships passing through the night and the experts are discussing completely different issues. But most importantly, and I say this in very careful words, be it on document production, the midstream case management conference, or the experts, that's your way as counsel to make sure that the tribunal learns the case. Often tribunals are ruling on document production without full knowledge of the case, and often tribunals are reading the expert reports for the first time on the eve of the hearing, and that's very important. That's enough for now. Thank you.
Thank you very much. Right. Florian.
Thank you, and thank you, first of all, to the organizers for organizing this wonderful event and for inviting me. I'm going to deal with a topic that has been quite prominent in the recent past, illegally obtained evidence. When I speak of illegally obtained evidence, I mean genuine evidence that is in principle reliable, but has been obtained by a party illegally, so using illegal means. And when you look at the problem, there seems to be a strong tension between two principles. On the one hand, arbitral tribunals should establish the true facts. Arbitral tribunals should not, normally knowingly, disregard a part of the facts and a part of the relevant evidence, and arbitral tribunals usually don't like to do that. On the other hand, a party should normally not use illegal or unethical procedural means to gain an advantage, and it somewhat offends our sense of justice if a party gains a procedural advantage by acting illegally. And that tension is presently unresolved, and probably there will never be a clear yes or no answer, but there are factors to take into consideration. And I'm going to look at those in this short presentation. First of all, looking briefly at the practice of the domestic courts, because that's a topic that is relevant in the practice of all courts of the world. And I've looked in particular at the practice of Austria, my home jurisdiction, and England, a prominent common law jurisdiction. And the general tendency seems to be that the courts say, we want to know the truth, we want to see the evidence, regardless of how the evidence was obtained. If it was obtained illegal, there will be a sanction, but that's not our problem. And arbitral tribunals have, I would submit, have adopted a somewhat more nuanced approach by probably engaging in a more careful weighing exercise of what speaks in favor and not of admitting illegally obtained evidence. Briefly looking at the procedural background, according to Article 9.1 of the IBA rules, arbitral tribunals have discretion to determine the admissibility, relevance, materiality, and weight of the evidence. and there is a general consensus that arbitral tribunals may, under this provision, admit but also reject evidence that was obtained illegally. Article 9.3 of the 2020 edition of the IBA rules has added a separate provision explicitly dealing with illegally obtained evidence, providing that the arbitral tribunal has the power to reject illegally obtained evidence, but arguably that has not changed materially the law, but merely brought a clarification of that issue. Now, going briefly to the case law, there is a line of cases, and mostly the published cases are from investment arbitration, but we all know, and I know from my own practice, that there are lots of other cases also from the area of commercial arbitration where illegally obtained evidence is relevant. If you look at the cases, and I'm giving just an overview of a few ones, UCOS dealt with WikiLeaks evidence without much discussion whether it was illegally obtained or not. Arguably, under US law, it was illegally obtained. The tribunal nevertheless took it into account. A deeper discussion about illegally obtained evidence is in Methanex versus US. There, the claimant procured evidence by illegal trespassing and actually obtained great volumes of documents from waste containers from a party's property. And the tribunal said, well, this is clearly unlawful, and the claimant hasn't provided a coherent explanation as to how he obtained that evidence. And what also seemed to have played a role is that the claimant subsequently lied about this to the tribunal. And the tribunal then also held that the evidence as such wasn't very relevant for its decision, and overall it said that it was fairness required the exclusion of that evidence. Now, Libananko versus Turkey, and that's an issue that we I think have already briefly discussed. There, the Turkish authorities intercepted communications between Counsel and the claimant, and sought to produce that evidence in the arbitration, and that communication was mostly privileged. And the arbitral tribunal was very firm in rejecting that evidence, saying that the integrity of the proceedings required that this is not admitted, and the main decisive ground for that seems to have been the legal impediment of privilege. Karatube versus Kazakhstan concerned leaked evidence that was not obtained unlawfully by the party itself, but by some undisclosed hacker, or at least it could not be established that the party who relied on that evidence was behind the leak, and the tribunal admitted the evidence generally, but excluded the privileged evidence. And the last case I'm going to report about is EDF versus Romania, an interesting case. There, the investor alleged the solicitation of a bribe by a minister, or not by the minister personally, but by people close to the minister, and the claimant secretly wiretapped such a conversation in which somebody close to the minister solicited a payment. And the claimant sought to submit the transcript and the tape. And the tribunal rejected that, saying, first of all, the tape was unreliable because the native tape was not produced, and so it couldn't be excluded that it was tampered with. And then it also said that the conduct of the investor was illegal because secretly recording a conversation was illegal in Romania, and that it would be against the principle of good faith to admit such an evidence. I'm going to come to that. That second part of the tribunal's reasoning is a bit questionable, I would submit, because what else should you do as an investor if you are confronted with such a situation? So there is a sort of pressure on the investor to defend itself. Looking at those cases and looking at the practice of various courts, or at least the published practice of the courts, the conclusion is that tribunals are not outrightly rejecting or admitting illegally obtained evidence, but usually taking a decision after a careful weighing exercise. And if you look at it, I could distill 5 considerations which are relevant, and of course that list is not exhaustive, and others may be equally relevant. I mean, first of all is the severity of illegality and the public interest that is involved. To give a very extreme example, the use of evidence that was obtained or procured via torture. When there is a general consensus, this is not admissible, it would be contrary to human rights, and that concerns not only the witness evidence itself, but also documents that were obtained through the use of torture, even if those documents are genuine. Secondly, the degree of the involvement of the party. If there is a difference, if the illegal action is committed by the party itself, or if somebody else breaks into the party's records and then leaks it to the internet, although it is not always clear whether that leak is still not in some way linked to the party. So that's a different issue. But generally, the greater the involvement, the higher the chances of rejection. Third, and that's more an implicit criterion that is not often mentioned explicitly, the probative value of the evidence. If the evidence is very relevant, tribunals tend to admit it because they want to establish the true facts. If it's rather irrelevant, it's rather easy to reject it because it's anyway not relevant. So that seems to be an implicit criterion, but that nevertheless may play a decisive role. Fourth, and that's really a quite difficult criterion, is the situation of the party that commits the illegal action. So there is a difference, at least I would submit that, and there is court practice to that effect, that if you break before the start of proceedings, you break into your opponent's offices, you conduct a sort of DIY disclosure, or if there is the attempt of procedural fraud by one party, and the party is under some pressure to establish the truth. And there, at least some courts have said, well, there is a sort of self-defense situation where something that is in principle illegal may be justified to prevent another crime. And that may be, that the Austrian Supreme Court said that, for instance, there was an attack with an axe, and which was in itself illegal, and the other party filmed that and used the video, and there the Supreme Court says, well, the filming may in itself be illegal, but it is justified in the circumstances of the case. Of course, the seriousness of the crime plays a role here. Fourth, is there a legal impediment? If there is a legal impediment such as privilege and you couldn't produce the documents anyway, even if legally obtained, then there is little reason to allow it because it was illegally obtained. So that was in the Tube case, for instance, decisive. And fifth, overall procedural fairness and justice. I'd like to conclude with one observation. You can read when you read the cases, and especially some less recent court cases, you can often read that the truth always needs to be established, and admitting the illegally obtained evidence serves the purpose of establishing the true facts. That seems a bit naive to me, because if you obtain all your opponent's records, you will use what suits you, but you will not use what doesn't suit you. So that is not necessarily the truth that comes out of that. And the conclusion or the recommendation I would submit arbitrators should take into account is, if they are considering admitting illegally obtained evidence, they should request full disclosure of the circumstances and of all the evidence that was obtained by the party wishing to admit the evidence. Otherwise, you would really create a one-sided situation. Thank you.
Thank you, Florian. We had a similar case where the claimant engaged an expert, let's put it this way. He was a former Mossad agent, and they were located in Israel, where recording a phone interview requires only the consent of one party and not the consent of both parties. And then sitting in Israel, they would call the country where the other relevant people were located, including the witnesses on the other side, and recording and pretending to be someone else and pretending to give them benefits and employment with UN agencies and so on and so forth, and trying to obtain information, illicit information that could be relevant to the proceedings. But the recording of those interviews without the consent of the interview was illegal at the place where those people were located. So the expert was saying, well, it is legal as a matter of Israeli law, which is where we are located, but of course it was illegal, even possibly criminal, under the law of the place where the interviews were located. And of course we opposed that, and the tribunal said it is unlawfully obtained evidence, and then it was stricken out of the record. Can we ask for one, maybe someone has a question? Yeah, Sergey.
So I can stop shouting, thank you. But then in ICC, the International Criminal Court, or the ICTY, the Yugoslavia Tribunal, right? There were several interesting decisions where the reliability and credibility of WikiLeaks were questioned, and those were not admitted, because the US government famously takes the position that they neither confirm nor deny the authenticity of the WikiLeaks, for instance. So it's a very interesting question on whether you can say that, well, we cannot prove that those documents weren't tampered with. So sure, they're available for the whole world to see, but are they really authentic? Has there been any change there? So that's an interesting consideration. And the second, which is really cutting edge, I think, is the use, or the acceptability of use of AI-generated evidence. So not just research that sometimes finds its way into memos and submissions and all the hallucinated cases, but AI-generated evidence, meaning summaries of long documents, meaning sort of cross-checks or comparisons between different data sets. All this can be done by AI, and it's a very big and difficult question as to whether this can be admitted. Now, there are a lot of state courts, well, maybe 10 to 20 state court decisions that I've seen, US mostly, which deal with this, and mostly in the overwhelmingly, state courts deny or do not allow, do not admit AI-generated evidence because you cannot attest the veracity, you can prompt it differently, and it'll give you a different answer. But it's interesting how tribunals will inevitably deal with this point. Thanks.
If I may just the short, very interesting comment on your comparison with criminal law. I think it's very interesting, and when you review the case law, it seems, and sometimes the distinction is made explicit, it seems that there is a sharp distinction between criminal law, where the criminal courts seem to take the position, well, it is the state against an individual, and they're much more liberal in excluding the evidence, rather than in arbitration or civil litigation, where basically mostly the evidence, even if it's questionable somehow, will be admitted and then later weighed.
I think we are 10 minutes behind, so I think it's the right time to break for coffee and dessert. Can I just invite everyone to thank our excellent speakers for their presentations.
Dear colleagues and guests, we suggest that we leave the coffee break for after the fourth session in order to save time. But after that, you will have a lot of time for networking and for discussing everything. But right now, we suggest to go straight to the session 4. And for the session 4, it is my pleasure to say that we will explore the comparative